Hi, my name is Amanda Rocha. I'm an estate planning and probate attorney in California, and today I'm going to talk to you about the Homestead Declaration. Before I get into that, I want to give you my contact information. You can find me on my website at www.amandarocalaw.com. You can comment down below if this platform allows you to do that, or you can find me on social media at amandarocalaw.com. Now, the reason that I want to talk to you about homestead declarations today is because it's a question that I'm commonly asked, and there must be some sort of misconception going around about what a homestead declaration is and the protection that it gives you. It isn't something that I was familiar with before I ever started law school and I never connected it to estate planning. So the fact that people are connecting it to estate planning so much means that it needs to be explained. So first, let's just discuss what is a homestead declaration, what is your homestead. Now, as always, I'm only going to be discussing California law and federal law if I discuss federal law. I don't discuss laws that are state specific in other states because I only practice in California and I only know about California's laws specifically. So if you live outside of California, this might be educational, but it cannot apply to other states. Now that that's out of the way, in California, we are allowed to declare our home, our residential properties that we live on as our homestead, either by filing a declaration or it's automatically applied. So you don't actually have to file a homestead declaration in the state. A lot of people tend to do that anyway. But what does it even mean? So by declaring your residence, your homestead, what you're saying is you want it to be protected. Asset protection in case something would ever happen to you and a creditor were going after you for any amount of money. So there are some new developments in this. As of 2021, the amount that is protected has increased. So it used to be a little confusing based on whether you were married or single, but now it is minimum $300,000 equity in your home, up to $600,000. That's going to depend on the value of your home in the year that it is in the county that you live in. So I'm not going to get into how to calculate all of that because if you're having an issue with this, then you need to hire an attorney to help you with it. But just know that as of January 1st, 2021, the homestead exemptions are between $300,000 and $600,000, and that's been increased from a minimum of $75,000 based on our home prices in California. Also, starting January 2022, this will be increased for inflation, which is something that wasn't done before either. So now that we've got that little piece out of the way, let me explain what it means. So if you have a creditor coming after you, a non-judgment creditor, so someone who doesn't have a judgment from a court, just a regular creditor coming after you, they can't go after your home unless it's a certain kind of creditor. So there are ways that liens could be put on your property, but it's not for all kinds of run-of-the-mill creditors. Those are things for like child support and other necessary things that would be against public policy for you not to pay. So basically, what you're protected from is regular creditors and Chapter 7, only Chapter 7 bankruptcy for the equity in your home between $300,000 and $600,000. If you have anything above that, if you have equity in your home above the value that you would be qualified for, then that's not protected, unfortunately. So basically, not all creditors are going to be exempted from this. So if you have a judgment creditor, a court has placed a judgment against you for whatever the reason, your home may not be protected. It's just going to depend on your certain situation and what's going on, and you would be advised to speak to an attorney personally about your situation. I've been asked lots of questions about this recently and also not so recently. And so let me first say that this is only protecting you from California specific issues. Federal claims are not covered, are not protected by California law, I should say. So this is only if you've got a claim against you in California, not a federal claim, not something from the IRS, let's say. That's federal. That's not going to be protected by the homestead exemption. So how does this tie into estate planning? I think I figured out why people are asking me this question. Because generally, estate planning has nothing to do with your creditors unless you're going through probate. So I'm going to connect the dots for you. First, if you have filed a homestead declaration on your home, that does not mean that your home is going to avoid probate. It does not mean that your home is protected from all types of creditors from you or anybody else. That also does not mean that you don't need an estate plan. You absolutely need an estate plan. This doesn't protect you from anything except really Chapter 7 bankruptcy and a few random creditors. But if the creditors have a real claim and they want to go to court and get something filed, a judge can make the determination that they can still take what they're owed. It just depends on the kind of creditor that they are and whether the judge sees that they have a right to take what they're asking for. So there is something called probate homestead. And I think people may be hearing this and confusing it with regular estate planning outside of probate. Now, what a probate homestead is when you are the primary provider for your family. If you were to pass away, the surviving spouse and the children of the decedent, the person who's passed away, sometimes have a right to file a request for a probate homestead, which is basically during probate, you're asking the judge to take into consideration that the assets that your family member left behind should be used to provide for you in the way that they were providing for you. And so the judge has to weigh all sorts of decisions when thinking about probate homestead and whether or not to apply it to a certain situation. Number one, they have to weigh the needs of the family, the spouse, and the children. Number two, the creditors. Number three, the property involved. So is it community property? Is it quasi-community property? Is it separate property? And also, a probate homestead does not necessarily mean that the actual physical residential home would be saved from the creditors. It could mean that a certain amount of money were set aside to give to the family instead of the home. It just depends on the situation. So I think this is where people are getting confused, although nobody yet has ever said to me, what's a probate homestead? I think it's just getting lost somehow in the shuffle. And another thing to think about, or to know, I guess, about probate homestead is it doesn't last forever necessarily, and it doesn't mean it's not guaranteed. So this is a totally separate issue and a totally separate thing than a regular homestead declaration. I just wanted to throw it out there and let you know that there are two different things that I'm talking about here. A homestead declaration filed with the recorder in your county for your home versus a request for a probate homestead, which would be in probate court. If you have any questions about this, please feel free to reach out. We can work through the details. You can find me through my website, www.amandarocalaw.com. You can comment down below if this platform allows you to do that, or you can find me on social media at amandarocalaw.com. Thank you.